Okay, so right. So then we have appeal, and then we will have the answer to the lawsuit, at which point you can move on to discovery, and they can start requesting documents and summoning people in for depositions. So when we get to that point to discovery, when they request documents, is it do they have to know exactly which documents they're looking for? And do they have like any legal power to compel Citadel or Robinhood or whoever it is that they're requesting documents for to provide those documents? Or is it like a discretionary thing?
So the standard for discovery is material and necessary. So the documentation that you're asking for has to be material and necessary to prove your case. So if they said, for example, we need to see the emails from, Robinhood and Citadel between the dates of, January 1st and, January 31st, to establish the conspiracy. That I would argue would be material and necessary. But let's say, just as an example to show you what wouldn't be material and necessary, what would be deemed what the other side would call a fishing expedition. We want to see the emails for the last year and a half, prior year and a half, from all the emails from 2019 to 2021. Now the judge might say, well, that's too broad of a brush, too broad of a stroke. You don't need emails going back 2 years. You're going on a fishing expedition. You're trying to find more than you need. It's discretionary, like you said, Josh. That's true. It's ultimately it'll be up to the judge. I mean, look, there's case law, that the judge and the attorneys will cite to support why they believe they're entitled to XYZ discovery. But again, in this type of case, the discovery is going to be substantial. Obviously it's going to be, at this point, they only have 10,000 pages. And a note about discovery. They keep saying, 10,000 pages of discovery, 10,000 pages of discovery. The reality is, when you get served with discovery, when they'll drop, I don't know if you ever seen it maybe in movies, but there's these scenes where there's these mass litigation, and then there's a scene where like they're loading trucks with documents, bins and bins and bins. And that's done partially on purpose. Because it's like, okay, here's all the discovery. Good luck finding a needle in a haystack. They want to frustrate you or have you miss something. Think about it. If they, out of 100,000 pages, maybe only 5 of those pages actually have the smoking gun or the document that you really need, but they're going to make you work for it. Think about it. Think about what they had in their complaint. They said they went through 10,000 pages of documents, but how many of those actual pages were in the complaint that established, the possibility of there being an agreement? There was like 3 pieces of paper. And I'm sure they were stuck, way deep in the middle somewhere. They're not handing it to you in sequential order,
Definitely not.
So,
I mean, so I'm curious, actually, just on the subject of emails. Say they requested that they said, right, okay, we want all the emails between the 1st of January 2021 and the 31st of January 2021, and Citadel were like, well, we don't have them anymore. Is there like any precedent to, I don't know, seize computers, or is there like a way to compel them to hand over whatever they might have? Like do they have, like, could they have just like burned the servers and deleted the emails, and like would that be enough to protect them at this point? Like, will they just like get away with it, like Hillary style? Or
yeah, I mean, look, Josh, I mean, not to use the word conspiracy in the other sense, but yeah, I mean, look, there's always potential for shenanigans. I mean, for that to happen, but then but if you get into all that type of stuff where there's a possibility that did they scrub the servers, did they delete the emails? Okay, so then there's a couple of things that can be argued under that, right? There's what's called an adverse inference. So that basically says, well, the emails don't exist anymore. So the court can take what's called an adverse inference, which means, well, we can infer that the fact that those emails don't exist anymore, that there's something adverse, and there was a reason why those emails don't exist anymore. Now that's not a strong, adverse inferences aren't really that strong because it's still based on a lot of speculation, obviously, and that's not going to win you a case. I don't look historically when you look at big cases, you rarely hear situations like the Hillary situation where, parties don't come forward with evidence and, they try to hide it or obstruct, justice or anything like that. I mean, that's like high government, conspiracy, type of stuff. I don't think that happens on a daily basis. I'm sure people will disagree with me on that and say that it happens all the time. Judges are in people's pockets. In my experience, I haven't seen that. I just haven't seen it. So I'm not going to say that something is true just, because that's what people think. I mean, I've been doing this professionally for a long time, and I've never felt that any decision against me was made because, someone was in somebody's pocket. That's just not something that I've seen in practice.
Okay. So I'm curious as to whether you're aware of any like legal precedent or like cases upon which we can look back in this sort of like antitrust case where like conspiracy to fix prices has been alleged. Like, is this like a brand new sort of thing in terms of like what has been taken to court before? Like, obviously there's like allegations that fly around that hedge funds are manipulating prices all the time, but is there times when these sorts of firms have been taken to court in the past over things like this? No, this is a very particular set of facts. This is not, this is unprecedented, and it's unprecedented to the effect that no brokerage has ever fully taken away the buy button from retail investors before. Right? There's no precedent for it. So that when there's no precedent, right, this is what would be considered or called a case of first impression, right? But it's really not, because conspiracy isn't new, right? Conspiracy cases exist for the last, 50 years or more, right? There's always been people conspiring against other people to, get money, to take money out of people's hands. Yeah. So from the legal perspective of conspiracy, this is not a case of first impression. But from the factual aspect of the case, it's first impression, because this has never been done before. Everyone keeps using the word unprecedented, and that's true. This is unprecedented. So basically, when you have that situation where it's unprecedented, you have to, use analogies, right? You have to find cases that are analogous, to this. And there's tons of them, I'm not going to get into them there because they're so filled with like, over the top legalese that, your head would explode. I don't even like reading them, constitutional law cases it's the class in law school that nobody wanted to take because it's just the decisions are like over 100 pages long. They're dry as can be. And, they're so dense, that it really requires a level of focus that, it's hard to summarize. So that's why I try to just say, listen, there's case law always, for the most part, supporting both sides to an argument, right? That's the legal system. Yeah. The law says X, Y, and Z, right? Basically, this is how they teach you in law school how to figure out how cases are decided, right? They call it the IRAC system. It's issue, rule, application, conclusion. So basically, that's for the rest of a lawyer's life. That's basically, in a nutshell, what you try to do. What's the issue? Okay, the issue is there is a conspiracy between Robinhood and Citadel to take money out of the hands of investors by taking away the buy button, so the price of the stock can go down, so Citadel can cover their short positions, right? With not cover, but so Citadel won't get burned by their short positions. All right, so that's the issue. The rule is, in order to prove a conspiracy, you have to show X, Y, Z. The application of the rule. Based on these facts, we cite to this case, and this case. We cite to Twombly. We cite to various other cases that are out there from the highest courts possible. Remember, the higher level court, the more required the courts are to follow it, right? So there's two different types of
case law. There's case law that's from the higher courts, which the courts have to follow, right? Yeah. And then there's there's lower court cases, and those cannot be taken at full value. They're called persuasive. So there's no mandatory requirement that they're followed by the courts. They're just persuasive. So and then once you apply those laws, then they come to a conclusion. And remember, the person who comes to the conclusion in this case is the judge.
Yeah.
So it really just depends on how do these other cases that are analogous to this set of facts fall, in favor of who? And that's really what it boils down to. But there's so many levels, even after, like I said, after discovery, while discovery is going on, there's still another layer of motion practice that gets done. So, I mean, the litigation process takes a really long time to get to the actual trial part, which most of the time never happens, because while all this is going on, all this back and forth with the motions and the arguments, someone behind the scenes is trying to settle this thing.
Yeah. I mean, your talk about constitutional law classes there just like sent me way back to when I was in university, and we were studying European law, and we had to do cases like factor term, and oh my dear goodness, it was just reams and reams and reams of pages. And then the year after I finished, 1/3 of my degree was wiped out by Brexit. I don't need to understand European law anymore. But so I sympathize with people who with not wanting to go deep into the complexities of constitutional law cases. That's never really where you want to go if you want to keep things at least brief or entertaining.
Yeah, well, that's the thing with this case. I mean, this case is, all the cases are con law cases. These are all Supreme Court cases that they're relying upon. The attorneys are citing to various higher court cases, at the Supreme Court level. And that's the interesting thing too, Josh, about the appeal, to go back to that for 1 second. Remember, so this is right now in the lower court, right? This is the lower district court where the case is filed. Okay, so then that gets appealed to the next level, right? The United States Court of Appeals, right? Then after that, that's not the last appeal. They can still appeal yet again. Remember, you have multiple levels of appeals. So you have, after that, then you can ask for certiorari to the Supreme Court. And then if cert is granted, then you got to wait for the Supreme Court to make a decision. So when I said that this case can be appealed, that appeal could, think about it. The first level of appeal alone can take a year. Then the next level of appeal can take another year. And then for it to get to the Supreme Court, forget about it. These things don't happen overnight. So that's the other thing. I mean, that all goes back to the whole delay thing.
Yeah. It's obviously like legal cases take a long time. So anyone who's thinking this is going to be a quick wrap up is mistaken. Like the court case is not going to trigger the MOAS people. Registering with ComputerShare is far more likely to do that. Thanks for making it all the way to the end of the video. Don't forget to like, share, subscribe, and leave a comment for us in the comments below. Let me know what you thought and if you'd like to see more of this from the show. Thank you, and we'll see you again next time.